All right, let's bring in now Mbekezeli Benjamin, a Research and Advocacy Officer for Judges Matter. He joins us now via video link. Thank you so much for your time, Mbekezeli. Of course, for the sake of our viewers, I want us to go back to what was clarified in court this morning. So what we essentially saw is 3 applications brought forward by the 3 organizations mentioned in that earlier story. And in fact, the DA's application has 2 parts. Just talk to us about the essence then of the various arguments by these applicants.
Good afternoon, Unati, and good afternoon to the viewers. You're quite right. There are 3 different applications that have been filed by 3 different organizations, which is the DA, Freedom Under Law, and Corruption Watch. The latter 2 are civil society organizations. And the essence of all 3 applications is that they believe that the National Assembly, in selecting Dr. John Hlophe to be the MK Party's representative on the Judicial Service Commission, was irrational. They say that it was irrational because it was in conflict with the provisions of the Constitution, which require that the National Assembly or Parliament as a body do all in its power to protect the independence, the accessibility, and effectiveness of the judiciary. So if you look at the decision to select Dr. Hlophe, who they say has been impeached as a judge and was found to have misconducted himself, to put him as a member of the JSC, to select other judges, is irrational. It does not follow the powers that the Constitution gives to the National Assembly.
How would the court then deal with the urgent application, to interdict Dr. Hlophe from participating in the process of the JSC pending the finalization of their reviews of the National Assembly's decision to appoint him?
Yes, that's quite an important point, Unati, because what is the focus of today's proceedings is what is called the Part A part of the case, which is essentially trying to get an urgent interdict to block Dr. Hlophe from sitting on the JSC. And that has its own requirements, and that is what the parties have spent a great deal of time today doing. Because the argument is that if Dr. Hlophe is allowed to continue to sit on the JSC with the interviews coming up next month, then he will do harm to the interview process, and that harm will be irreversible. And so what the 3 parties are saying is that the court must urgently intervene to prevent that harm from happening. They say that if Dr. Hlophe is allowed, for example, to sit on the selection of the judges of the Western Cape, including the Judge President of the Western Cape High Court, that will present a conflict of interest between his own interests and the interests of the Judicial Service Commission. And so that should not be allowed to happen. And so the court should immediately intervene to prevent that from happening, because if it is allowed, then the water sort of will be out under the bridge, and there won't be an opportunity to reverse such a harm.
I want us to then focus on how the National Assembly itself is being challenged. I mean, the DA has described its application to have, Hlophe's appointment to the JSC rescinded as a precedent-setting case. What then does that say about the way in which the National Assembly is now being criticized as not really taking due process to make appointments or applying its mind?
So the National Assembly has taken a neutral stance in this case. We heard from the Speaker of the National Assembly saying that the National Assembly is not saying that one party or the other is correct in this case. What it's only here to do, what the National Assembly or the Speaker is in court to do, is to explain the process of how the National Assembly decided on designating Dr. Hlophe as a member of the JSC. We heard that what the Speaker is saying is that there were basically 2 sides to the debate. There was certain parties who objected to Dr. Hlophe's designation. Other parties supported Dr. Hlophe's designation. And one party, like the ANC, decided to just sit it out because they had argued that there is no provision in the Constitution or in the conventions of the National Assembly, which allow parties to block the selection of another party for a designation. So what essentially the Speaker is saying is that she was guided by the conventions of the National Assembly, and those conventions didn't give her any power to prevent Dr. Hlophe from proceeding to be designated. And so in this case, she is taking a neutral stance and leaves it in the hands of the court to decide what is the proper role and function of the National Assembly when it comes to designations of this kind.
Is this a watershed moment, do you think, in your view, in your opinion? I mean, I'm listening to just various voices weighing in on this, and some saying, how can you have an impeached judge then sit on the very body that essentially impeached him?
It is a watershed moment, Unati. Some of these situations that we are encountering, particularly in this case, probably were not contemplated when the Constitution was written. There was no one who had in their mind that an impeached judge would one day be designated as a member of the National Assembly to sit on the JSC. And so we are basically, and what the court will be doing, will be filling in the colors of the Constitution and sort of setting out the contours of where exactly the powers of the National Assembly and the Judicial Service Commission fit in, and how they should relate to each other. So in that way, it is a watershed moment. We will definitely be getting new judicial precedent on the constitutional powers of the National Assembly and that of the JSC. But it's also, I think, as a requirement of the JSC, which over the last 3 years has been undergoing a particular process of reform. It will be interesting to see how that will affect the process going forward. So in that respect as well, it is a watershed moment.
Mbekezeli, thank you so much for your time. Really do appreciate it. Mbekezeli Benjamin, there is a Research and Advocacy Officer for Judges Matter.